Welcome back to the Vault. I'm Michael Cola. You found the book. You love it. The author's excited too. You write a check. Everyone shakes hands. You sign something that feels official enough, and you start telling investors you have the rights. 8 months later, your distributor's E&O lawyer runs the title report. Turns out the author's publisher never let go of the film option, or the author already sold audio rights to a production company you've never heard of. Either way, your clean acquisition has a giant hole in it, and it surfaces at the worst possible moment, right when a bond company or distributor is deciding whether to write you a check. That is the literary purchase agreement, and it's how you make sure that hole never exists in the first place. So here's what it solves. This document doesn't just transfer rights, it forces the author to warrant in writing that nobody else has a claim on them. That warranty is what distributors and E&O carrier is actually underwriting when they insure your picture. So before we dive in, we have our typical disclaimers. First, this is for educational purposes only. It's a starting point, a drafting tool for independent filmmakers. It does not constitute legal advice, legal representation, or a legal opinion. 2, no attorney-client relationship is formed by reading, downloading, or using this template. You are not a client of the lab, and the lab is not your legal counsel. 3, jurisdiction varies. This is drafted on general principles of U.S. contract law and common industry practice. Have it reviewed by counsel licensed in your specific jurisdiction. And 4, use this at your own risk. The lab assumes no liability for any errors, omissions, or consequences from using this document. Now let's dive into a couple of the quick usage notes. A few things to think of first. Use this moment you've optioned or agreed to buy the underlying rights to a novel, article, podcast, or memoir, any pre-existing literary work you didn't write yourself. If your writer's drafting an original spec script for you, you want the writer agreement plus a certificate of authorship instead, not this document. The clause doing the heavy lifting here is Section 4. It's the representation and warranties. A distributor's E&O carrier isn't underwriting your handshake with the author. It's underwriting that section, Section 4. If it's thin, your bond company and your E&O policy both will know it. And this is a purchase, not an option. An option lets the underlying rights lapse back to the author if you don't exercise in time. Useful when you're not sure the project's getting made, but once you're financing and forming your SPV, a live option sitting outside that entity is exactly what a lender's counsel flag. This template assumes the option period is over. You're acquiring it outright, so title vests in the company cleanly and permanently. That's also why there's no reversion clause in this contract. Rights reversion documents exist elsewhere in the library for a reason. They're the right tool for a conditional grant, like a first look deal. This isn't that. Every distributor and completion bond underwriter reviewing your chain of title is looking for an unbroken, unconditional grant. So now let's dive in. As with any contract, we have our title and then our typical who, what, when, where, and why. So your date, who the author is, what they're going to go by is as the author, the company name, what state the company's in, and then whether it's an LLC. From there, what they're working on, and the date of first fixation. Underneath this, we have the recitals. Before we dive into Section 1, the recitals already tell you the shape of the deal, that the author's the sole owner, the company wants the motion picture and TV rights, and the author's signing the certificate of authorship concurrently. The last recital is doing the real work. It's already flagging that Exhibit B isn't optional paperwork. It's baked into the deal from the very first sentence. That's right here. So let's look at Section 1. The grants of the rights, the clean sale. So this is the whole engine of the document. It is a present absolute assignment, not an option, not a license, nothing that reverts. Title vests in the company outright throughout the universe and in perpetuity. Notice that the language covers digital and streaming rights explicitly, and it names the SPV directly. The company can license or assign straight through to the special purpose entity, its lenders, completion guarantor, sales agents, and distributors without needing to go back to the author. And it says flat out, this grant is not an option license or grant subject to reversion. If a publisher or an agent later argues the rights were only ever conditional, this is the sentence that says otherwise. Reserved rights. Let's slide down to this real quick. Quick note here, if you're leaving anything with the author, publishing rights, stage rights, it has to be explicitly listed on Exhibit A, which we will get to when the document, when we reach it at the end. If nothing's listed or Exhibit A is blank, then nothing's reserved. The grant in Section 1 is complete and total. Section 3 is your purchase price. It's standard, your payment terms, and your offering. You could potentially offer a bonus tied to commencement of principal photography. That would go here. Representations and warranties. This is the undisclosed encumbrances. This is the one the author has to warrant flat out that no publisher, agent, or prior producer holds any conflicting option, license, lien, or encumbrance, that any prior grant has fully expired or been terminated. It also covers the ground people forget, that the work isn't already the subject of an existing production, that the author hasn't pledged or encumbered any of the rights elsewhere, and that there's no libel or privacy claim buried in the material and no pending or threatening litigation that could interfere with the company's quiet enjoyment of their rights. If any of that warranty is thin or false, this is where the conflict will show up in writing before you spent $1 in production, not in the title report after. So let's dive into Section 5, chain of title and further assurances. This is the chasing 6 months later clause. This ties execution of the certificate of authorship, Exhibit B, to the company's obligation to even pay the purchase price under Section 3. Get it signed the same day as the main agreement. While the author's still in the room, it obligates the author to sign anything else the company reasonably needs later. A short form assignment in a recordable form for the Copyright Office, quitclaim deeds, updated certificates at the company's expense. And if the author won't sign within 10 business days of a request, this section gives you a limited power of attorney to fall back on, coupled with an interest to execute those documents on the author's behalf. A tool you'd rather never use, but one you'd rather have and not need. Let's go into Section 6. This is our typical credit clause. This is standard language that has a carve out that says if you have an inadvertent failure, you'll fix it. Section 7 is our standard no obligation to produce. So this should look familiar. The company's only real obligation is payment, no pay or play, no promise. The picture gets made. Section 8, the no injunctive relief. I love this clause. It's important to have in your documents. The author waives his injunction relief entirely. Their remedy for a breach by the company is damages, not a court order stopping you from making the film. But notice it only runs in one direction. Here, the company keeps full equitable remedies against the author if the author breaches the Section 4 warranties. That asymmetry is on purpose. The company's the one financing the distribution and distributing off the strength of this grant. So you need that. Section 9, indemnification. So the author indemnifies the company, the SPV, and their officers and assessors for any breaches of Section 4. And the company indemnifies the author only for material from the company added after the fact, not derived from the work itself. And this is one clause that survives termination. Section 10 is your termination or breach. So it's worth a beat here. If Section 4 warranty turns out to be false, company can go after the purchase price and resulting damages, but termination doesn't revest the rights back to the author. The Section 1 assignment is irrevocable and survives termination. This is what keeps your chain of title intact, even if it's breached. Assignment and notices, counterparties, successor and assignment is force majeure, governing law, entire agreement, and severability are all your standard boilerplates. You'll see these throughout most of the non-day film contracts. They basically state many different things. One, that you can assign it to the SPV and the SPV can sign anything else, that this is how notices are made, that electronic signatures are required, that force majeure may happen, that the governing law is what state you're in, and that even if this document is deemed unconstitutional or invalid, the sections survive. Just that one clause or section is deemed invalid. So here we have the party's signature page. This is where you'd get it filled out by the author and then the company. And then we slide down into Exhibit A. This is the reserved right schedule. This is the schedule section 1 pointed to earlier, 5 lines: publishing and print rights, live stage rights, sequel, prequel, remake rights, merchandising rights, and catch-all other rights. Leave it blank and you've sold everything. Check the box and describe the scope, and a piece stays with the author. One production note attached right on the page. Whatever you reserve here, carry it forward into your Phase 7 ancillary tracking rights on the contract tracker. Otherwise, it's easier to treat as a reserved right as a grantor the moment you're deep into a sequel and merchandise conversations stand you down the line. So it's just really important to remember to have these and get them. And then again, whatever you're leaving for the writer, you put in here. And then we're going to look at Exhibit B, your certificate of authorship. We've already covered this in earlier videos, but this basically states that your production company is the one that has the rights and is considered the author for the work. So let's get back to the top now. This is your literary purchase agreement. It's how you turn a handshake with an author into a chain of title that the distributor's lawyer will actually clear. One thing it doesn't do, it doesn't clear life story or depiction issues for real people referenced in the work, and it doesn't register your copyright. Those are separate documents further down the checklist. The depiction release is coming next month, as well as the Form PA application. So download this template, links below, fill out every bracket, especially with the state of formation and the project title. Get Exhibit A filled in if they're reserving anything, but don't fill it in if you don't want them to. I suggest you don't. Get Exhibit B signed and notarized the same day as the main agreement while the author's still in the same room. Remember, everyone, be kind and let's get to work. Thanks for visiting the Non-Day Filmmaking Legal Lab. Hi, I'm Michael Cola.